I just figured out from a brand new filing in the last few minutes how the Department of Justice is going to try to save the former FBI Director James Comey indictment. They're going to use a statute to argue that the indictment that was dismissed by Judge Curry because Lindsey Halligan was illegally appointed actually suffers from some sort of defect. And because of that defect, there is a statute that allows, for technical reasons only, a re-indictment even after the statute of limitations has run on a particular charge for an additional 6 months. But it has to be a technical defect in the indictment. That's not what Judge Curry ruled when she threw out James Comey's indictment for perjury. And they already admit the statute of limitations has run, but now it's been revealed how poor and weak their argument really is. And I found it in this brand new filing in the last few minutes, which we will also post on Legal AF Substack. Welcome to Legal AF on Tuesday. I'm Michael Popok. Let's get to the brand new filing just in the last few minutes, 9 a.m. Eastern time. Here we go. Gerald Richmond, Professor Richmond, lawyer for James Comey, files a motion around Thanksgiving to try to obtain back, to claw back his files, his emails, all of the documents that the government has retained for the last 5 to 8 years and put up on a shelf. They used in an entirely different investigation under an entirely different set of warrants. That was the box of docs, the Richmond docs, that were trampled on, that were just completely abused by Lindsey Halligan, the then U.S. attorney, and the FBI in September when they took the box down without a warrant and started going back through it, violating the Fourth Amendment rights of Daniel Richmond all over again. So the motion in front of Judge Kolar-Catelli is to get those documents back and to prevent them from being used by the government or anything related to it, any fruit of that poisonous tree in any subsequent indictment. And we know that the Trump administration is trying to re-indict James Comey to try to clean up the mess caused by Lindsey Halligan's illegal appointment. Now, despite the fact that Judge Curry fired Lindsey Halligan 3 weeks ago, guess what? She's back on the pleadings. Here we are on the last page. On page 18, she's listed, the first person listed is Todd Blanche, Deputy Attorney General. Second person listed is Lindsey Halligan, United States Attorney, Eastern District of Virginia, Florida, bar number 109481. Lindsey, take a hit, take a powder. Like Alina Habba, your buddy up in New Jersey. You got fired. Stop listing yourself on pleadings and pissing everybody off as the U.S. attorney when you're not the U.S. attorney. At best, you're the acting U.S. attorney. But here on page, this is where they reveal themselves. On page 15, it says, we'll put it up on the screen with me too. And Richmond is flatly mistaken that any charges related to the underlying conduct are time barred. That would mean they had 5 years from the testimony in September 2020 that James Comey gave to Congress to bring the indictment. They brought it with like a day to spare. But the indictment was ruled by Judge Curry to be invalid, not because of a technical defect, but because it was a void act of an illegal U.S. attorney. So her document itself was what we call void ab initio, void at the start, not for a technical defect that can be cured in the 6-month rule that they're citing. But so they make two admissions here. One, they have no other claims against James Comey, because if they had them, they would list them. They'd say, "Oh, we've got other claims and criminal charges that we're going to bring against James Comey." I don't see that. In fact, they say Richmond is flatly mistaken that any charges related to the underlying conduct are time barred. The statute of limitations has indeed expired on the charges with which the grand jury indicted Comey. See, there you would drop a footnote that says, "But we've got other charges," but they don't say that. But 18 United States Code 3288 expressly allows the United States to re-indict. Then they take a half-assed quote, "whenever an indictment, charging a felony is dismissed for any reason after the period prescribed by the statute of limitations has expired, citing a case, United States versus Macklin from 1976. But they got a problem because that rule, 3288, only applies, and the case law says so, to a technical defect in the indictment. They left out an element. They had a form problem. They had a typo. The magic language was missing. And so 3288 says you got 6 more months to fix a bad indictment. But that wasn't the problem. It wasn't that the indictment was defective, although I think the indictment is defective when it relates to James Comey. It was that the person getting the indictment was illegal, was a non-entity, was a stranger to the court, Lindsey Halligan. Therefore, her indictment is void and does not stop the statute of limitations clock, which they admit has already run. And they can't use 3288 because it's not a technical defect. That's the best they got. That's a loser. And that's an admitted loser. What they're trying to convince Judge Collard-Catelli is that this is nothing more than a motion to suppress evidence that should be brought only by James Comey, masquerading as what's called a federal rule of criminal procedure 41G motion to obtain documents, reclaim documents in violation of the Fourth Amendment. Now look, Judge Fitzpatrick, the magistrate judge, is the one that opened the door here. He looked at all of the issues. He looked at the grand jury. He looked at the pleadings. He looked at the motion practice. And he said that Daniel Richman's Fourth Amendment rights were horribly violated, along with rights of James Comey as a defendant in the case. That there was a callous disregard for Richman's rights because they used a warrantless search on old documents, did nothing to segregate the documents out prior to the indictment, then used the tainted material through an FBI agent who should never have seen everything in the Richmond box to begin with, certainly not attorney-client privilege material, and let him testify to the grand jury. It's as simple as that. And once Judge Fitzpatrick wrote that, it was natural for Richmond to now want his documents back. And so what is being sought here by the government is to dissolve the temporary restraining order that was issued on Sunday, blocking the government from using the Richmond files to re-indict James Comey. But now they've let the cat out of the bag. They are going to try to re-indict James Comey. They're going to argue that it is a technical defect in the other indictment, that the statute of limitations hasn't run, that they have another 5 months to bring the indictment. And we're going to have a battle now in front of Judge Nachmanoff, who's the judge assigned to the prosecution, and ultimately to the Fourth Circuit Court of Appeals in Virginia, and up to the United States Supreme Court about this issue. We'll continue to follow it. But a couple of interesting things I wanted to bring out to you right now, sort of little mini bombshells. Lindsey Halligan still signing pleadings to piss off everybody, except her own boss, Donald Trump, as the U.S. Attorney for the Eastern District of Virginia when she was fired by Judge Curry. Note to Judge Curry, amend your order to bar Lindsey Halligan from holding herself out and impersonating a U.S. attorney, and do an order to show cause and bring her in on a contempt hearing immediately. That was my little side note to the judge. Secondly, we have an admission by the Department of Justice that time has lapsed, that they're going to try to argue a technical defect in the indictment to try to re-indict James Comey because they're trying to get a clean indictment of James Comey and of Letitia James before they make the decision whether they're going to appeal Lindsey Halligan getting bounced. But apparently they don't think they have to appeal anything, because I'd like to hear them say in court what they think Judge Curry's order firing Lindsey Halligan did if she gets to continue to sign papers. Well, it's just one judge's opinion. It's a federal judge, Judge Curry. The lawyers involved. Get on this. I'm Michael Popok. I'm glad you're here. Hit the free subscribe button. You're here on Legal AF on Tuesday. Help us continue to grow our pro-democracy channel. Till my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.